I want to do a video here to talk about what's happening in foreclosures across the state of Florida right here in the first quarter of 2014. We are engaged in what I call the foreclosure purge of 2014, and that is state policymakers have decided that it's in the best interest of this state to flush out all of the cases that have been pending in foreclosure courtrooms all across this state. Now, some amount of lip service is paid to the need to maintain some adequacy of due process or respect for the rights of litigants that exist in this foreclosure purge. But the reality is, from my experience and the experience that are being reported by consumers and advocates across the state of Florida, due process and justice is taking a backseat to the higher goal of clearing these foreclosure cases out. Now, looking at the numbers here, and I'll post this link into this video, we have a report here from the Office of State Court Administrators that indicates that as of June 30th, 2012, there were 377,000 foreclosure cases pending all across the state of Florida. But as of January 31st, 2014, that number had been whittled down to 240,000 cases all across the state of Florida. Now, while that may be deemed some amount of progress, I take the proposition that when this is occurring in the space of an absence of due process, or at least a diminution of due process, and when this is occurring in a course of proceedings and a culture and climate in which the due process rights of litigants that appear inside our courtrooms are being diminished or in many cases desecrated, this is not progress. And part of what is occurring statewide is those advocates and pro se people and court watchers and frankly thoughtful judges and those that are part of the judicial process are recognizing that as we engage in this foreclosure process, something very sacred is being lost, and that is an attention to the dignity of the judicial process and the dignity of the rights that appear before courtrooms. I mentioned that statistic to you earlier that 377,000 cases were pending in 2012 that had been whittled down to 240,000. The next page here reports that that reduction in cases, that total number of reduction in cases of 141,000 comes as a result both of case dismissals and of cases that were disposed of by judges. Now, the second page here reports that that number is 57,000 cases were dismissed and 81,000 cases were disposed of by judges. Historically, that number trended at roughly 50%. 50% dismissed, 50% disposed of by judges. But it's very compelling to me that the number here that as of January 2014, 57,000 cases were dismissed. That's important because that indicates that either something was wrong with the case and the plaintiff voluntarily dismissed it, or the judge dismissed the case because they looked at it and decided that it shouldn't proceed, or the case was dismissed as a result of maybe a modification or short sale or something like that. But, you know, this indication that that vast number of cases, 57,000 of them were dismissed, is clearly an indication of something wrong with foreclosures in the state of Florida. But the next page reports the average monthly dispositions, and they compare the year 2011 to 2013 and then report into 2014. And this number is important because it had, again, been deemed appropriate in a state priority that the average monthly disposition of cases be increased. And so we see it going from 14,000 a month up to 20,000 a month average dispositions in through 2014. Now, the final page here is very important as well, because this final page lists the average number of filings in 2012, 2013, and then progressing into 2014. And you see that while the average monthly filings had been roughly 14,000, 15,000 in 2011 to 2013, that number dropped off significantly in 2013 to 4,000, but it's coming back up into 8,000 cases, new foreclosure cases being filed in 2014. Now, this figure is important because it doesn't reflect what's actually happening out there in the marketplace. While there is a dramatic reduction in filings of foreclosure cases, that doesn't mean that's because the economy's gotten better or people are current on their payments or their taxes are being paid or the insurance is being paid. The reason why there's been such a dramatic downturn in foreclosure filing cases is because what's happening in those previous pages. The banks and the law firms are overwhelmed right now dealing with those prior cases. They can't even get to the new cases that are going to have to be filed here eventually. So what we have here is, if you think of it like a bucket, there's a bucket that all these new foreclosure cases that exist in are sitting in, but the bottom of that bucket doesn't exist. So just as quickly as we flush out old foreclosure cases, right up at the top, we're flushing new foreclosure cases into the system. Let's talk about what's happening in foreclosure cases. Again, we're in this very, very disturbing period where courts have made a decision that they need to be flushing foreclosure cases out. And they're doing this, believe it or not, oftentimes in opposition by the plaintiffs, who don't really want these cases to be flushed out into the system. And let me explain why. You know, many of these cases, these foreclosure cases that are pending, are properties that are in bad condition or in areas that already have a preponderance or a high number of foreclosure cases pending in there. So we've got these pockets in communities all across this state where we have a high concentration of poverty and economic problems. And those are the areas where these foreclosure cases largely are isolated. And so what's happening is the banks, even though they already have a large number of final judgments of foreclosure, they're now being forced to take more and more final judgments of foreclosure. There have been some reporting. There was a Salon article by David Dayan a few months ago that talked about in Palm Beach County, there were more than 10,000 final judgments of foreclosure that had been entered, but no final no sale had occurred. Now, I suggest to you that if you look at that number of new final judgments, 141,000 cases, what you're going to find is there's going to be a vast number of those that sales will not occur. Let me be clear about that data. I guess those sales wouldn't occur on the 57,000 dismissed cases, but of the 81,000 cases that were disposed of by judges, and I take that to mean a final judgment in the vast majority of those cases, and so 81,000 final judgments and sales could occur. I think what we're going to see happening is, even though we've got those 81,389 final judgments, the banks will not quickly be moving to set those final judgments to sale. So what we're going to see in communities all across the state is that we have a continued glut of final judgments, but final judgments that do not have sales associated with them. Again, that article by David Dayan in Salon, and I'll try to attach that to the video here, shows where even when they've got these final judgments and sales haven't occurred, the properties just sit there vacant and abandoned. And that's an important thing to talk about right now, because here's what's happening. While the state courts are pushing all of this inventory of unwanted foreclosures out into the marketplace, it's putting a burden on local government and law enforcement, because in these vacant and abandoned houses, they become magnets for crime and for squatters and other problems. And so what the state is doing is creating a worse situation, and here's why. In my experience, and those at banks and policymakers that are following this, we recognize that in many of these cases, foreclosure cases pending across the state, the banks are making a conscious decision not to proceed with foreclosures on them. They are content to allow people to stay in these homes. I think, frankly, they've made policy decisions that it makes more sense for them to keep a homeowner in that home, making mortgage payment, or not making mortgage payments, but keeping the lights on and at least keeping it occupied. But this issue is running cross purposes with the state that's trying to push all these foreclosure cases out into banks that don't otherwise want them. Which brings us to another part of the discussion. Right in the midst of this foreclosure purge, it's heading straight along and crashing into two other big concepts, and that is the national mortgage settlement and the implementation of the new Dodd-Frank regulations regarding mortgage servicing. Now, reflect back to the national mortgage settlement. The banks were caught stealing from the federal government, committing crimes in the context of foreclosure. We can call them crimes, but our policymakers decided to use euphemisms and say things like robo-signing and surrogate signing, when in fact it's perjury, it's fraud, it's forgery. But the fact of the matter is that the national mortgage settlement was the result of the crimes that banks committed being investigated by attorneys general, federal agencies all across the country. It resulted in this national mortgage settlement that resulted in payment of fines back to state government. Here in the state of Florida, a couple $100 million as a result of that money got dumped into the state court system, into the state legislature, passed a bill, Senate Bill 1852, and again, I'll try to append that to this video here. And that money that was paid as a result of bank crimes has funneled its way back to the state court system in a truly Kafkaesque expression of what has occurred. The very money that the banks and institutions paid as a result of the crimes that they committed are being used to fund the court systems, which are now being used to punish the consumers that were the victim of the bank crimes. And here's exactly the way it happened. Senate Bill 1852 describes the hundreds of millions of dollars that's funneled its way back to the state court system and is being used to pay magistrates, senior judges, and pay for technology upgrades focused specifically on the foreclosure crisis. Now, I don't recall in any of the press releases or propaganda that was released as part of the national mortgage settlement any discussion about how this money that the banks were paying as a result of their crimes was going to be used to turn around and punish consumers. But that is, in fact, exactly what is happening, because these very courtrooms that are resulting in vast numbers of final judgments of foreclosures, vast numbers of Florida consumers and citizens being thrown out into the streets, were paid for exactly with the money that came from the national mortgage settlement. Now, the thing that is so infuriating about this is the precise terms of the national mortgage settlement provided that that money that the banks paid as a result of their crimes was supposed to be used to help consumers. But that money is not being used to help consumers. That money is being used now to abuse and punish consumers at the hands of a justice system that's far more interested in clearing foreclosure cases and entering final judgments to banks than it is examining the court files and identifying the very instances of fraud and forgery and abuse that occurred and that led to these abuses. Now, so we've got the national mortgage settlement money that's being used to fund this court system that's likewise being used to churn out foreclosure judgments at a record rate. This is occurring in the context of the new Dodd-Frank rules that take effect January 10th and that provide important protections to consumers and important requirements to the servicers that are prosecuting these foreclosure cases. The CFPB rules require the banks and institutions to engage in a very robust form of loss mitigation and consideration, and explicitly prohibit the banks from continuing with foreclosure cases while a loss mitigation application and review process is occurring. Now, what is happening all across the state of Florida is that banks are trying their best in many cases to comply with the terms of these new CFPB regulations, the Dodd-Frank rules, but as they appear in front of judges, they're being told by judges, we won't cancel sales, we will not continue trials because of this pressure that we're under to clear foreclosure cases. And again, this is the Kafkaesque nature of what's occurring in the state court system. Think about this. The very money that is being used to fund these court systems, which was provided to the courts by the banks that were engaged in crimes, that were engaged in abuses that are the subject of the Dodd-Frank rules, are now being told by the state court system, despite the fact that if you proceed with sale or you proceed to trial, you are in violation of the CFPB rules. We're not going to cancel these trials. We're not going to cancel these sales. In fact, forcing the banks and institutions to engage in conduct which violates the Consumer Financial Protection Bureau rules, the Dodd-Frank rules, and everything else. So that illustrates the very real problem in foreclosure right now. I'm happy to report that in many instances, defense and consumer advocates are engaged in good faith efforts to settle with banks and institutions. And in many instances, we're having some great success. I report a climate of collegiality, professionalism, and cooperation that exists in the bank side in many instances. Still a lot of problems out there, but in the vast majority of our files, we're able to work out these cases and get consumers in their homes under terms that they can agree with, because we're working cooperatively with the banks. But this is running headlong into this madness of the foreclosure purge, which is prohibiting, in many cases, the banks from being able to thoughtfully consider loss mitigation options. Now, I've reported some really dire circumstances. I've kind of given the worst news about what's happening out there. But the reality is that in cases that are properly defended, where we're in there really doing our job and have the space and the opportunity to litigate a case properly, we're able to turn great results. We get trial victories all the time. We get cases dismissed pre-trial from procedural moves, and quite frankly, for other tactical steps that we're taking. The point to be made, however, is this. The foreclosure litigation environment is very difficult right now, and consumers that might have had some success in years past, months past, doing things on their own, going it on their own, are going to find that they're going to be caught up in this purge in a way that they're not prepared for, stepping into courtrooms and feeling the pressure that the courts are under to clear these cases, and running headlong into that pressure, not feeling like they're getting a fair shake or their fair day in a courtroom. As a result of this, I encourage you to be very careful if you're a consumer engaged in this foreclosure process. Quite frankly, I encourage everyone to reach out to their legislators and to judges to the extent that you're able. Go into courtrooms and examine what's happening, and reach out to court staff, reach out to judges, and leave some comments with them, if you can, about what you see happening in courtrooms. To that end, I am posting up here, and Mark Stope and some others are putting a request out there that consumers write to us and leave with us your experiences and the thoughts on what you see happening in courtrooms, so that we might share these with policymakers in a thoughtful and constructive way. I'm convinced that policymakers at the highest levels are not really aware of what's happening in courtrooms. So they don't get to hear the things that we advocates hear and see every day. We might deem them abuses in the court process, or the rough edges of what's happening in courtrooms. So what we're asking for is consumers to share with us your experience, thoughtful and respective written recordings of what's happening. Give those to us so that we can share these with policymakers, in the hope that we might be able to back off this pressure a little bit and return the court to some dignity and respect for the litigants that appear before you, before the court system.